Hey, this your car?
It is. Is there a problem, officer?
I've had reports about someone matching your description. What are you doing out here this time of morning?
I work here. I'm a researcher. That's my lab right there.
ID now.
My badge is right here. I also have my...
Not that. Government issued. And keep your hands where I can see
I'd like
them.
to understand what I'm being stopped for.
You're being stopped because I said so.
The morning I nearly missed the most important briefing of my career, I was sitting in a legally parked car in a marked researcher bay, wearing my lab coat, with my institutional ID hanging from my neck. I wasn't speeding, I wasn't arguing, I wasn't doing anything except reviewing my notes for a 8:15 a.m. team briefing on a Phase 3 trial that had taken 11 years to reach. The officer didn't see any of that. He saw a black man in a parking lot. He had decided that black man didn't belong in. And everything that followed, the stop, the escalation, the recording, the federal complaint, the termination, the $6 million the city quietly paid to make it go away, all of it started in the next 4 minutes. But before I take you through what happened that morning, I want to ask you something simple. What city are you watching from? I'd drop it in the comments right now. Because this story didn't happen in a vacuum. It happened in a city with a research district, a police department with a complaint system, and a culture that decided certain professionals needed to be checked, regardless of what they were wearing, where they were parked, or what they were carrying in that building behind them. If you've never heard my name before today, hit that subscribe button before this video ends. What happened to me happens to people who never get a platform to tell it. Your subscription is how more of these stories reach more people who need to hear them. Now, let me take you back. It was a Tuesday in early October, 7:43 in the morning. The research district was already humming, that particular quiet energy of a campus that runs on federal funding and grant deadlines, where the lights in the labs are on before the sun is fully up, and the parking lot fills with people who have clearance badges, not visitor passes. I had been at the Institute for 9 years by that point. I knew every security camera angle in that lot. I knew which bay was closest to the side entrance. I knew the parking permit system because I had submitted the administrative form to get mine renewed 6 weeks earlier. I pulled into bay 14. Marked, permitted. Legal in every documentable way. I put the car in park, pulled up the briefing notes on my laptop. The trial data had come in overnight. 847 patient responses across 4 clinical sites. The numbers were doing something extraordinary, and I needed to walk my team through the implications before the 9 a.m. call with our federal program officer. I was still reading when the shadow crossed my window. Not a knock. Not a greeting. A shadow first. And then a voice that had already made its decision before it reached my door. "Hey, this your car?" I looked up, uniformed, city police, standing at my driver's window with the flat expression of someone who had already written the next 10 minutes in his head. I set my laptop down, both hands visible on the wheel before he asked. "It is," I said. "Is there a problem, officer?" He looked at me, then at the car. Then, for exactly 1 second, at the white lab coat I was wearing and the lanyard ID resting against my chest. Then his eyes moved away from both of them, unbothered, unchanged. "I've had reports," he said, "about someone matching your description. What are you doing out here this time of morning?" I gestured toward the building directly behind me, glass front, institutional signage, a keycard access panel visible from where he was standing. "I work here," I said. "I'm a researcher, that's my lab." He didn't look at the building, not once. "ID," he said, "now." I reached toward the lanyard at my chest, the institutional ID that had my photograph, my name, my department, and the federal agency that co-funded our work printed on it in clear, unambiguous text. "My badge is right here," I said. "I also have my—" "Not that," his voice dropped. "Government issued, and keep your hands where I can see them." I set my laptop bag down slowly on the seat beside me, both palms up, deliberate, documented. On every movement calculated for the camera I had confirmed was recording from the moment he walked into its frame. "I'd like to understand," I said carefully, "what I'm being stopped for." The silence lasted 2 seconds. "You're being stopped," he said, "because I said so." And his hand moved to his belt. What I reached for next, and what it said on it, is the reason this man no longer has a badge. That's next. I want you to understand what that building actually was. Because the officer standing at my window had looked at it once. One glance, maybe 2 seconds, and dismissed it the same way he had dismissed my lab coat and my lanyard. It was just a building to him. Glass and concrete. Something in the background. But that building was the reason I had moved to this city 9 years earlier. It was the reason I had turned down 2 offers from private pharmaceutical companies that would have tripled my salary. It was the reason I drove the same car I had bought in my 2nd year as a postdoctoral fellow. Because the work happening inside those walls was not the kind of work you walked away from for a larger paycheck. Let me tell you what was inside it. The Hargrove Institute for Translational Medicine occupied 4 floors of a purpose-built research facility at the northern edge of the district. It had been established through a joint funding agreement between the university and the National Institutes of Health, a federal partnership that meant our work was not just academically significant, it was a matter of federal research priority. The institute housed 7 active research divisions: oncology, rare disease pharmacology, our immunological response, pediatric neurology. 2 divisions I am not at liberty to describe in full because their trial data remains under federal review, and mine, the Molecular Synthesis and Drug Development Division. 11 active patents, 4 compounds in various stages of clinical trial, 1 compound that had already completed trials and was, at the time of this incident, in active distribution across 47 countries. That compound, the one that had taken 11 years to develop, that had survived 3 failed formulations and 2 near cancellations of funding, that had been the subject of a New England Journal of Medicine paper that accumulated more than 4,000 citations in its first 18 months, was keeping people alive. Not theoretically, not eventually. At the time, Officer Greer put his hand on his belt and told me I was being stopped because he said so. 3.2 million people were receiving that drug as part of their active treatment protocol. He looked at the building it came from and looked away in under 2 seconds. The parking bay I was in, Bay 14, was part of a researcher-designated zone that required an administratively issued permit to access legally. The permit was visible on my dashboard. It had my name on it, my vehicle registration, my department, and an expiration date 14 months in the future. The zone was marked with signage on 3 sides. Authorized research personnel only, permit required, violators subject to institutional tow. Not municipal signage, or institutional signage, because the parking infrastructure on the north side of the lot had been developed and maintained by the Institute under a city land use agreement. The city's parking enforcement authority in that zone was limited to vehicles without valid permits. My permit was valid. The stop had no legal foundation from the moment it began. I knew that. I had known it within 15 seconds of Officer Greer's shadow crossing my window. 11 years of working adjacent to federal regulatory frameworks will do that. You develop a precise sensitivity to the boundary between lawful authority and the performance of it. What I was watching was a performance. There were 4 external security cameras covering the north parking lot. Camera 1, mounted above the building's side entrance, angled to capture the full researcher bay zone. In Camera 2, positioned at the lot's entry gate, capturing vehicle entry, plate numbers, and permit verification angles. Camera 3, attached to the light post 3 bays east of mine, direct sightline to Bay 14. Camera 4, interior facing, capturing the building entrance corridor and the immediate exterior apron. I had walked past those cameras every working day for 9 years. I knew their angles the way I knew the layout of my own lab. And standing in the sightline of 3 of them with no probable cause, no reasonable articulable suspicion, and no legal basis for the stop, Officer Greer was constructing a documentary record of his own conduct that he had no idea existed. The Institute's security system recorded continuously, 72-hour rolling retention, automatically archived on federal incident flag. He had no idea the morning light was flat and grey, the particular overcast of an October morning that flattens shadows and makes everything equally, evenly lit. No harsh contrast, no dark corners, everything in Bay 14 was visible. My car, my permit, my lab coat, my lanyard, my hands, all of it documented. All of it already being recorded before the conversation had moved past his first 4 words. The building behind me, the one he had glanced at and dismissed, was not just my workplace. It was about to become the evidentiary foundation of a federal civil rights complaint, a six-figure legal filing, and a termination proceeding that would close permanently within 90 days. But Officer Greer didn't know what was in that building. He just knew what he thought he saw in Bay 14. And what he thought he saw had nothing to do with lab coats, permits, or the 3.2 million people whose names he would never know. He was about to find out what kind of mistake that was. But first, let me tell you who I am, because that part matters more than you might expect. My mother wanted me to be a doctor, not a researcher, not a scientist working in a federal facility on compounds that would never carry her son's name on the bottle. A doctor, the kind who sees patients, who has a waiting room with his name on the door, who comes home at a predictable hour. I understood what she meant. She had watched too many brilliant black men from our neighborhood pour themselves into systems that extracted their talent and returned nothing with their name attached to it. She had seen what happened when the institution got the credit and the individual got the experience. She was not wrong about the pattern. What she didn't know, what I barely knew myself at 22, was that the work I was being pulled toward wasn't the kind you do for credit. It was the kind you do because the alternative is that the work doesn't get done. And if the work doesn't get done, people die from diseases that were solvable. That's not a rhetorical statement. That is the clinical reality of rare disease pharmacology. My name is Dr. James Okafor. I completed my undergraduate degree in biochemistry at Morehouse College, where I graduated first in my class and received the Departmental Award for Independent Research, a project on membrane protein synthesis that my advisor later told me was the most sophisticated undergraduate thesis he had reviewed in 20 years of teaching. I didn't tell you that to impress you. I'm telling you because in approximately 4 minutes, a uniformed officer was going to look at me and conclude, with complete confidence, that I did not belong in the parking lot of the institution that had recruited me out of my doctoral program with a federal fellowship offer. I want you to hold the full weight of that gap. After Morehouse, I completed my doctoral program in molecular pharmacology at Johns Hopkins. 4 years. Dissertation focused on targeted drug delivery mechanisms for treatment-resistant cellular environments, the biological problem at the center of why certain diseases defeat every pharmaceutical intervention thrown at them. My dissertation was published in its entirety in the Journal of Molecular Medicine. It has been cited 2,300 times. I then completed a postdoctoral fellowship funded directly by the National Institutes of Health. 2 years embedded at the Hargrove Institute, working under Dr. Caroline Voss, one of the foremost rare disease researchers in the country, on a compound that had been theoretically promising for a decade but chemically unstable in every formulation attempted before mine. The breakthrough came in my 14th month as a fellow, not dramatically, not the way it happens in films, no sudden revelation, and no moment of cinematic clarity. It came at 11:30 on a Wednesday night, in a lab that smelled like ethanol and burnt coffee, when a stability test returned numbers that were different from every previous iteration in a way that was unmistakably significant. I ran the test 4 more times before I went home, all 4 confirmed. I joined the institute as a full research scientist at the end of my fellowship. I was 29. In the 11 years that followed, I filed 11 patents with the United States Patent and Trademark Office, each one covering a specific innovation in molecular synthesis, a process refinement, a delivery mechanism, a formulation technique that addressed a previously unsolved problem in the development of treatments for rare cellular diseases. Patent number 7 was different. Patent number 7 covered the core synthesis process for a compound that, after 11 years of development, 3 failed formulations, 2 near cancellations of federal funding, and a Phase 3 clinical trial involving 847 patients across 4 countries, had become the first approved pharmaceutical treatment for a degenerative cellular condition that had previously had no treatment protocol at all, no management option, no palliative standard of care, nothing. Before that compound, a diagnosis meant a trajectory and a timeline. After it, 3.2 million people, and growing, had a different conversation with their physicians. The morning of the incident, I had left my apartment at 7:20. I wore my lab coat over a pressed dress shirt and dark trousers. My institutional ID lanyard, the one Officer Greer's eyes would move across and dismiss in under 2 seconds, carried my photograph, my full name, my title, my department designation, and the NIH co-funding insignia that indicated federal research affiliation. My laptop bag contained the overnight trial data from 4 clinical sites, 847 patient response records, 11 years of prior research architecture that the numbers were either confirming or complicating. I was thinking about the data when I pulled into Bay 14. I was thinking about my 8:15 briefing. I was thinking about the Phase 3 results and what they meant for the 34 patient advocacy groups that had been waiting on this trial for 3 years. I was not thinking about what a uniformed officer would see when he looked through my window. I had spent 11 years becoming exactly the kind of scientist who parks in Bay 14 at 7:43 on a Tuesday morning. It had never occurred to me that someone with a badge would look at me and see something else entirely. The shadow crossed my window at 7:44. I set my laptop down, both hands on the wheel. "Hey, this your car?" And I looked up at a man who had already decided the answer before he finished the question. What he did next, and what he said, created a record he will spend the rest of his life being unable to explain away. That record starts now. There is a specific kind of professional discipline that develops in a person who has spent 11 years working in federally regulated research environments. It is not patience, exactly. It is something more structural than patience. It is the practiced ability to separate what you are feeling from what you are doing, to keep the analytical process running cleanly even when the emotional environment is hostile, to document in real time, to note details with the same precision you would apply in a lab setting, because you understand that what you observe right now may need to be reconstructed accurately under pressure at a later date. That discipline is the only reason I did not say, in my first 30 seconds of interacting with Officer Derek Greer, exactly what I was thinking. What I was thinking was precise, and it was not quiet. What I did was quieter, more useful, and, as it would turn out, far more permanent in its consequences for the man standing at my window. Let me reconstruct what happened in the 4 minutes between Officer Greer's first word and the moment he made the decision that ended his career. I want to be exact about this. Not approximate, exact, because the recordings confirm every detail, and because the gap between what Officer Greer later claimed happened and what the 3 cameras documented is itself a significant part of this story. At 7:44 a.m., Officer Greer approached Bay 14 from the eastern pedestrian path that ran along the lot's perimeter. His body camera was active. Its timestamp would later confirm every interval I am about to describe. He reached my driver's side window at 7:44:18. He did not approach from the front of the vehicle, where my parking permit was visible on the dashboard, and he came from the side, directly to the window, which placed the permit outside his immediate sightline from the moment he arrived. Whether that approach was deliberate or habitual, I cannot say. What I can say is that it meant he had not confirmed or denied the vehicle's permit status before initiating contact. He had not checked the bay signage. He had not consulted any radio dispatch record. There was no report of a suspicious vehicle in that lot that morning. His own radio log, subpoenaed during the civil proceedings, confirmed 0 relevant dispatch activity in the research district between 7:30 and 7:55 a.m. He approached because he saw me. That was the totality of his probable cause. His first words, "Hey, this your car?" were delivered before he had examined a single piece of documentation. I verified a single registration detail or articulated a single specific behavior that warranted a stop. I answered calmly, both hands visible on the steering wheel before he asked. He looked at me, then at the car. Then, and the body camera footage confirms this, his eyes moved to my lab coat and lanyard for approximately 1.8 seconds. Then he looked away. I have thought about those 1.8 seconds many times since. What it takes for a person to register a white lab coat, an institutional ID lanyard, and a federal research facility directly behind the vehicle, and process none of it as relevant information. To look at an entire professional identity rendered in physical form and have it fail to interrupt a conclusion that had already been reached before the visual data arrived. That is not an oversight. That is a cognitive architecture that has been practiced into automaticity. When he said he had received reports about someone matching my description, I asked him calmly what description that was. He didn't answer. When I gestured toward the building and told him I worked there, that the lab behind me was mine, he didn't look at it. The body camera footage is instructive here. In the 4.2 seconds between my gesture toward the building and his next spoken word, Officer Greer's camera angle does not shift. His head does not turn. The building I pointed to, with its institutional signage fully readable at that distance, remains outside his field of documented attention for the entirety of the exchange. He was not gathering information. He had already gathered what he needed. He had looked through the window, and he had seen a black man in a car he had decided didn't belong in that lot. Everything after that was procedural enforcement of a conclusion he'd reached in the first 3 seconds. ID now. I reached for the lanyard at my chest. My badge is right here. I also have my... Not that. The interruption was immediate, before I had finished the sentence, before he had looked at what I was reaching for. Government issued, and keep your hands where I can see them. I set the laptop bag down on the passenger seat, slowly, both palms turned upward in my lap, not because I was complying with an instruction that had any legal basis, but because I was performing compliance for a camera that was capturing everything, every movement deliberate, every movement documented. My legal mind was running a parallel track beneath the conversation's surface, cataloging violations with the same systematic precision I applied to research data. No probable cause stated, no reasonable articulable suspicion described, no permit verification attempted, no building affiliation confirmed. Institutional ID visually registered and verbally dismissed before examination. Stop initiated on the basis of no documented criteria. 4 violations in 90 seconds. And his hand was now resting on his belt. I'd like to understand what I'm being stopped for. The silence that followed lasted 2 seconds. You're being stopped because I said so. His hand moved, and I made a decision. Not an emotional decision, not a reactive one. A calculated, documented, legally precise decision about what I was going to reach for, in what I was going to say when I produced it, and exactly how I was going to say it, knowing that every word was being recorded on 3 separate devices, and that at least one of them was in the hands of a man who did not know what he was about to see. What I reached for had 11 years of federal documentation behind it. What he said when he saw it guaranteed that this story would not end in that parking lot. It would end in a hearing room, with cameras, and counsel, and a settlement figure that made the city's legal team go very quiet for a very long time. That moment is 1 chapter away. There is a calculation that every black professional in America carries. It is not written down anywhere. It is not taught in any classroom. It lives in the body, in the specific muscle memory of how you move your hands when a uniformed officer is watching, how you modulate your voice when the person across from you has already decided who you are, how you perform legibility in real time for an audience of one who has no interest in being convinced. It is the calculation between what you know to be legally true and what you understand to be physically dangerous. I had run that calculation before. Not often. Not as often as many men who look like me. Because the lab coat and the institutional corridor had provided a buffer that I was clear-eyed enough to recognize as circumstantial, not guaranteed. But I had run it. And standing in that calculation is not an abstract exercise. It is a full-body experience that your nervous system does not distinguish from threat, regardless of what your legal mind is simultaneously producing. At 7:46 a.m., I was running it at a higher intensity than I ever had before. Officer Greer's hand had settled on his belt, not reaching, not drawing, resting, in the deliberate performative way that communicates intent without constituting action, the universal law enforcement posture that says, I have not moved yet, but I have decided I am willing to. I registered it, filed it, kept my palms visible, my laptop bag was on the passenger seat, my lanyard was against my chest, the building was behind me. 3 cameras were recording, 2 that Greer didn't know about, and 1 that he appeared to have forgotten about or deprioritized, because his body camera had been running since before he reached my window, and he was continuing to speak as though the recording was not a consideration. That told me something important about his assessment of the situation. He was not concerned about documentation. He had done this before, and documentation had never been a problem. "You're being stopped because I said so." The words landed with the particular weight of a phrase that has been used enough times to feel natural to the person saying it. Not aggressive exactly, settled. The tone of a man who has made this statement before and watched it work. Watched it produce the compliance response, the shoulders dropping, the voice softening, the slow resignation of someone who has decided that the cost of resistance exceeds the cost of submission. I did not give him that response. "With respect, officer," I said, keeping my voice at a consistent, documented volume, "a stop requires a lawful basis. I'm parked legally in a permitted researcher bay. I have displayed my institutional identification. I have told you where I work and gestured toward the building. None of that has been acknowledged or investigated. I would like to understand the specific basis for this stop." He looked at me for 3 seconds. 3 seconds of recalibration. I could see it in the slight tightening around his eyes, the minimal adjustment of his posture. He had expected a different register from me. The calm, precise legal framing had not been what he was prepared to process. "I told you," he said. "I've had reports." "What reports? Filed by whom?" Describing what behavior? "Step out of the vehicle." The crowd had not yet formed, not fully, but the research district at 7:46 on a Tuesday morning is not empty. There were people moving along the path that ran between the lot and the building's side entrance. Individuals with lanyards and laptop bags, and the particular purposeful stride of people who have somewhere specific to be in the next 12 minutes. 2 of them had slowed. I clocked them in my peripheral vision without turning my head. One was facing away from me, pretending not to watch. The other had stopped entirely, facing the exchange with the specific stillness of someone weighing whether to continue walking or stay. I registered both of them as potential witnesses. I registered the light post camera at my 11 o'clock position. And I registered the angle of Greer's body camera relative to the window frame. I was building an evidentiary map in real time while simultaneously maintaining the surface composure of a conversation that was escalating toward a decision point I did not want to reach but was prepared for. "I'm not going to step out," I said. "You have not provided a lawful basis for this stop. You have not verified my parking permit, which is visible on my dashboard. You have not examined my institutional identification, which I have offered twice. And you have not looked at the building I told you I work in, which is directly behind this vehicle. Last warning. I'm not resisting anything. I'm asserting my Fourth Amendment rights. There is a difference. And it is documented on your body camera and on my vehicle's recording system." The words recording system produced a reaction. Not large, not theatrical. A fractional stillness, half a second where his weight shifted almost imperceptibly backward, where his eyes moved for the first time to the dashboard of my car, where he registered, I believe for the first time, the small, steady red light of the dash camera mounted on the interior windshield. He looked at it for 1.3 seconds, then he looked back at me, and something in his expression rearranged itself, not into retreat, but into a harder version of what had been there before. The recalibration of a man who had been caught in something and responded by doubling down, because doubling down had always worked before, and retreat felt like a loss he was not going to absorb. "Well, get out of the car." "I'm going to reach into my laptop bag," I said, each word measured and clear, "and produce a credential that I would like you to examine carefully before you say another word. I am moving slowly. Both hands are visible. The camera is recording." The person who had stopped on the path was now standing completely still. The second individual had slowed to a near stop, phone in hand, positioned at an angle that I would later learn gave them a partial but usable sightline to the driver's side window. Greer's hand was still on his belt. The red light on my dash camera was steady. I reached into the bag. Inside that bag, beneath the trial data and the briefing notes and the 4 clinical site reports that represented 11 years of work reaching its most consequential morning, was a credential wallet. Black. On federal government issue. Embossed seal on the exterior. Inside it, my NIH Principal Investigator Identification Card. My University Research Faculty Card. and the document that had taken 11 years and 3.2 million patient outcomes to earn the right to carry. My full patent portfolio summary card, issued by the United States Patent and Trademark Office, bearing 11 registered patent numbers, my full legal name, my institutional affiliation, and a federal verification contact number that could be confirmed with a single 30-second phone call. I brought it up slowly, held it to the window, turned it so the embossed seal caught the flat October light. And I looked at Officer Derek Greer and I said, quietly, precisely, at a volume the dash camera would capture without distortion. I would like you to read what that says, all of it, and then I would like you to make a decision about how you'd like to proceed. He looked at it. I watched him read, and I watched the exact moment, documented on 3 cameras, confirmed in 4 separate witness statements entered into the evidentiary record of a federal civil complaint, when Officer Derek Greer looked at 11 years of federal documentation and said the 6 words that made everything that followed not just likely, but inevitable. Those 6 words are the next chapter, and they are the reason this story ends the way it does. You can buy these things online. 6 words, spoken flatly, without hesitation, without a single moment of consideration for what he was looking at, what it represented, or what the 3 cameras recording him would do with those 6 words for the next 18 months of legal proceedings. You can buy these things online. I want you to sit with that for a moment before I continue. Because Officer Derek Greer was not looking at a laminated novelty item from a costume website. He was looking at a credential wallet issued by the federal government of the United States of America, bearing the seal of the National Institutes of Health, carrying 11 registered patent numbers that existed in a publicly searchable federal database, attached to a name that appeared on the published authorship of a New England Journal of Medicine paper that had been cited 4,000 times by researchers on 6 continents. He looked at all of that, and he said, "You can buy these things online." I have been asked many times since, by attorneys, by journalists, by members of Congress during a hearing I will tell you about shortly, what I felt in the 3 seconds after he said it. I will tell you what I tell everyone who asks. I felt clarity, not anger, though the anger was present, running beneath the surface at a pressure I was managing with everything I had. Not fear. The fear had been present earlier, in the calculation I described in the last chapter, but it had receded the moment I made the decision to reach for the credential. What I felt in those 3 seconds was the specific cold clarity of a person who has just watched their opponent make the single most consequential mistake available to them. He had been handed an exit. He had looked at the exit, and he had walked past it. What came next was no longer my responsibility to manage. It was his to survive. I did not raise my voice. This is important, not as a character detail, but as a strategic and legal reality. The dash camera captured everything at a consistent audio level. My voice does not change register from the moment Greer arrives at my window to the moment Captain Reyes appears in the lot 17 minutes later. It remains measured, precise, and, I want to be honest about this, deliberately prosecutorial, because that is what I am. Not in the institutional sense only, though I was, in that moment, a federally credentialed researcher with 11 patents and a record that would be read into a congressional hearing transcript within 5 months. I mean prosecutorial in the structural sense. I was building a case. In real time, in a parking lot. With 3 cameras and 2 civilian witnesses and an officer who had just dismissed a federal credential as a purchasable prop. I was not the subject of this stop. I was becoming its architect. I want to make sure the recording captures this clearly, I said. I held the credential wallet higher, angled toward the dash camera, toward the body camera, toward the October light. My name is Dr. James Okafor. I am a principal investigator at the Hargrove Institute for Translational Medicine, a federally co-funded research institution operating under NIH grant oversight. I hold 11 patents registered with the United States Patent and Trademark Office. The patent numbers are listed on the document you are currently looking at and dismissing as a purchasable item. I paused. 1 beat. Deliberate. On patent number US 9,847,203 covers the core synthesis process for a compound currently in active distribution across 47 countries. As of last quarter's distribution report, That compound has been administered to 3.2 million patients. Those are living people. They are alive in part because of work done in the building directly behind this vehicle. Another pause. I want that on the record, all of it. Now, what would you like me to do next? Officer Derek Greer said nothing for 4 seconds. I know it was 4 seconds because the dash camera timestamp confirms it, and because I counted them in real time with the particular focus of a person who understands that silence, in an evidentiary context, is not empty. Silence is data. Silence is a gap in the counter-narrative. Silence, captured on a recording with a verified timestamp, is the absence of a response that a person with a legitimate position would have produced. He had no legitimate position. And for 4 seconds, the parking lot was completely quiet except for the flat ambient sound of an October morning. A distant ventilation system, a car on the street beyond the lot perimeter, the faint sound of someone's keycard reader beeping at the building's side entrance. 3.2 million people. 4 seconds of silence. The person who had stopped on the path was recording on their phone. I could see it in my peripheral vision, the screen held at mid-chest height, the slight adjustment of angle that indicated active capture rather than passive observation. I did not look directly at them. I did not acknowledge them. I kept my eyes on Greer and my hands visible and my voice at the same consistent, I-documented register. The second witness had not moved. They were close enough to hear everything that had been said in the last 90 seconds. Close enough to identify my name from my own statement of it. Close enough to be asked, 31 days later, to provide a sworn account of what they observed. Both of them would. Both accounts would be consistent with the recordings. Both would be entered into the evidentiary record without dispute. Before I tell you what Greer said when the 4 seconds ended, I need to stop here. Because this is the moment. This is the exact moment that the 6 people who came before me never had. This is the moment the complaint system failed to create for the research associate, the department chair, the NIH program officer, the biotech founder, all of them. The moment where the documentation was airtight, the credential was irrefutable, the witnesses were present, and the officer's own words were sitting on 3 separate recordings waiting to be subpoenaed. If this story resonates with you, if you believe that what happened in that parking lot and what happened to the 6 people before me needs to be documented and shared, subscribe to this channel right now. Every account like mine that reaches people who would otherwise never hear it is one more piece of evidence that this pattern exists. Your subscription is part of that record. And if you've been in a situation where your credentials, your professionalism, your belonging in a space was dismissed before it was examined, drop it in the comments. Because you are not alone in that experience. And this channel exists to make sure that stops being a private burden. When the 4 seconds ended, Greer spoke. What he said was not a retraction. It was not a verification attempt. It was not the 30-second phone call to the NIH main line that would have confirmed everything I had just told him and ended the encounter with nothing more consequential than an awkward morning for both of us. What he said was, I don't care what it says. Step out of the vehicle, now. And he reached for my door handle. What happened in the next 90 seconds, the physical contact, the witness response, the voice that cut through the lot like a blade finding a gap, is what transforms this from a story about one man's morning into the reason 34 research institutions rewrote their security protocols. It is also the reason the city's legal team did not contest a single clause of the settlement agreement. But that comes next. Right now, I want you to understand what those 4 seconds of silence meant. They meant he knew. He knew what he was looking at. He knew what he had said. He knew what the cameras had captured and what the witnesses had heard and what the credential in my hand represented. He reached for the door handle anyway. Some decisions cannot be unmade. This was one of them. When Derek Greer's hand closed around my door handle, 3 things happened simultaneously. The first was physical. I braced, not aggressively, not with any movement that could be characterized as resistance in the combative sense, but with the deliberate, a documented stillness of a person who has decided that their body is not going to make this easier for the person trying to remove it from a legally parked vehicle without lawful cause. My hands remained visible. My voice remained at the same consistent register it had maintained for the preceding 8 minutes. The second was legal. The moment his hand made contact with my door, the moment he initiated physical engagement without probable cause, without a lawful detention basis, with a federal credential literally in my hand that he had verbally dismissed on camera, the encounter crossed from unlawful stop into unlawful detention and physical assault. Those are not characterizations I applied retroactively. They are the classifications my attorney used 31 days later, and they are the classifications the city's own legal team did not dispute. The third was human. A voice came from the path behind him, clear, authoritative, the particular vocal register of someone who has spent enough years in institutional environments to know how to make a single sentence land like a termination letter. Officer, step back from that vehicle, right now. Dr. Sandra Reyes was the Hargrove Institute's Director of Research Security and Compliance. She had held that position for 7 years. Before that, she had spent 11 years as a federal compliance officer for the NIH's Office of Research Integrity, a role that had given her a precise and comprehensive understanding of the legal protections afforded to federally funded research personnel and the institutional consequences of violating them. She had been walking from the building's main entrance to the side parking lot to conduct a routine morning access audit, a weekly procedure she performed personally, because she believed that security compliance was not a delegable function at the director level. She had seen the patrol officer at Bay 14 from approximately 40 meters away. She had recognized me from approximately 30 meters. She had heard my credential statement, the full recitation of my name, title, patent count, and the 3.2 million patient figure, from approximately 15 meters. And she had watched Officer Greer reach for my door handle from close enough to read the timestamp on his body camera. Greer released the handle. He turned. Doctor. Reyes was already covering the last few meters between them with the stride of someone who has no interest in being intercepted before she reaches her destination. Who are you? Greer said. Dr. Sandra Reyes, Director of Research Security and Compliance, Hargrove Institute. The man in that vehicle is Dr. James Okafor, Principal Investigator, Molecular Synthesis Division. He holds 11 active federal patents. He is a credentialed NIH grantee, and he is parked in a permitted researcher bay with a valid institutional permit on his dashboard. She stopped 2 meters from Greer. You are standing in a federally co-funded institutional access zone. This interaction has been recorded by 3 external security cameras, one of which has a direct sightline to this bay and has been capturing audio since you arrived. I need your badge number, your precinct designation, and your supervising officer's contact information. Now. What happened in the next 11 minutes is best understood as a controlled institutional demolition, not chaotic, not dramatic in the cinematic sense. Methodical, the way things collapse when every structural support is removed in the correct sequence by people who know exactly which ones to pull. Dr. Reyes placed the first call at 7:58 a.m. It went to the Institute's legal counsel, a partner at a firm that specialized in federal research institution compliance and had represented the Hargrove Institute for 12 years. The call lasted 4 minutes. By the end of it, the attorney had confirmed that the incident met the threshold for a federal research interference complaint and had instructed Dr. Reyes to secure all external camera footage immediately and flag it for federal retention, removing it from the 72-hour rolling deletion cycle and placing it under legal hold. That instruction was executed within 6 minutes of the call ending. Every frame of every angle was preserved before Greer had finished writing his preliminary incident notes. The second call went to the university's vice provost for research, who had oversight responsibility for all federally funded research activities across the institution's affiliated centers. The vice provost called the university's federal compliance officer. The federal compliance officer called the NIH program officer assigned to our institute's primary grant, the same program officer who had himself been stopped by Greer 2 years earlier, whose complaint had been logged with the NIH Inspector General's office and left unactioned. He picked up on the first ring. He had been waiting without knowing it for exactly this call. The third call, the one that would, within 22 hours, reach a desk in Washington was placed at 8:14 a.m. by the Institute's federal compliance officer directly to the NIH Office of Research Integrity's duty line. The duty officer who took that call logged it as a potential federal research interference incident involving a credentialed NIH grantee. Under federal research protection protocols, that classification triggered a mandatory upward notification within 4 hours. It reached Washington at 12:47 p.m. While all of this was happening, Officer Derek Greer was standing in Bay 14, writing a preliminary incident report on his mobile device. His supervisor, Sergeant Paul Whitfield, 9-year precinct veteran, 3 prior internal affairs reviews all resolved without disciplinary action, arrived at 8:09 a.m. Whitfield reviewed the body camera footage on Greer's device. He watched it for 4 minutes and 20 seconds without speaking. Then he asked Greer one question. "Did you call it in before you approached the vehicle?" Greer said no. Whitfield put his own phone away without making a call. He stood in Bay 14 for another 30 seconds. Then he said, "Don't file anything yet. Don't talk to anyone. I'm going to make a call." The call he made was not to his lieutenant. It was to the precinct's legal liaison, the first indication, documented in Whitfield's own phone records subpoenaed during the civil proceedings, that the department's first instinct was not accountability. It was containment. Containment, as it turned out, was not available, because while Whitfield was on the phone with the precinct's legal liaison, Dr. Reyes was standing 6 meters away watching him, and the Institute's external cameras were recording everything in the lot, and I was inside the building, having been escorted in by 2 Institute security officers who had arrived at Bay 14 at 8:03 a.m., sitting in the security director's office, writing a contemporaneous account of every exchange with Greer in the precise, time-stamped, legally structured format that 11 years of federal research documentation had made second nature. 14 pages, completed before 9 a.m. Signed, dated, and transmitted to University Legal Counsel at 9:07 a.m. By 10:30 that morning, the following had occurred. All external camera footage had been placed under federal legal hold. The Institute's legal counsel had formally notified the city's legal department of a pending civil rights complaint. The NIH had logged a federal research interference incident. The university's communications office had been briefed and had begun preparing a public statement. 2 civilian witnesses had been contacted by Institute security and had agreed to provide formal accounts. And Officer Derek Greer was sitting in a precinct interview room, having been instructed by both his supervisor and the precinct's legal liaison to say nothing until a union representative arrived. The union representative arrived at 11:15 a.m. He reviewed the preliminary documentation for 40 minutes. When he came out of the interview room, and the precinct's legal liaison asked him how he assessed the situation, the union representative said 4 words: "Get the city's lawyers." The city's lawyers would spend 11 days reviewing the evidence before requesting a settlement conference. They would not contest a single clause. But before we get to the settlement, there is the matter of the 6 prior complaints that were about to be reopened, reclassified, and read into a federal record that would make the cost of Greer's 4-year pattern visible in a way that no single incident could have produced alone. That reckoning is next. 31 days after Officer Derek Greer stood in Bay 14 and told me I could buy federal credentials online, I sat in a conference room on the 14th floor of a downtown office building with my attorney, Dr. Sandra Reyes, in the university's Vice Provost for Research, and a 47-page internal affairs summary that represented the most comprehensive documentation of a single officer's pattern of conduct that the precinct's Internal Affairs Division had ever been compelled to produce. Compelled because they did not produce it voluntarily. They produced it because a federal magistrate signed a discovery order requiring its release as part of the civil complaint's evidentiary framework. The same complaint that by the time that order was signed had been joined by the NIH's Office of Research Integrity, the university's Federal Compliance Office, and an attorney representing 3 of the 6 prior complainants who had been located, contacted, and informed for the first time that their individual complaints were part of a documented pattern that had been systematically dismissed. 3 of the 6. The 4th had moved out of the country, the 5th declined to participate, but provided a written statement. The sixth, the biotech founder who had been stopped twice in the same month and whose attorney's demand letter had received a form acknowledgement and nothing else, called our attorney's office the morning after she was contacted and spoke for 40 minutes without stopping. The internal affairs summary confirmed what the 6 individual complaint files had suggested, but never established collectively, because they had never been reviewed collectively. Each complaint had been processed in isolation, assigned to a different reviewing officer. I evaluated against the narrow standard of the individual incident and closed without reference to prior filings involving the same officer. This was not an accident of administrative inefficiency. It was a structural feature of the complaint processing system that the union contract had specifically reinforced, a provision requiring that each complaint be evaluated solely on its own documented facts, without reference to prior complaints, unless a formal pattern review had been officially initiated by a commanding officer. No commanding officer had initiated a pattern review, not after Complaint 2, not after Complaint 4, not after the NIH program officer filed with both Internal Affairs and the Federal Inspector General's office simultaneously. The system had been designed to make patterns invisible, and for 4 years, it had worked. The Internal Affairs investigation that my incident triggered was not optional. Federal Research Interference Classification carries mandatory investigative protocols that operate outside the standard precinct review structure. The investigation was assigned to a senior Internal Affairs lieutenant who had no prior involvement with Greer's complaint history and no supervisory relationship with Whitfield or the precinct's commanding officer. Her name was Lieutenant Doreen Marsh. She had been with Internal Affairs for 14 years. She had conducted 340 officer investigations. She told my attorney, during a deposition taken as part of the civil proceedings, that the Greer file was the clearest pattern case she had reviewed in her 14 years, not because the individual incidents were the most severe she had encountered, but because the dismissal pattern was so consistent, so structurally uniform, and so thoroughly documented in the institutional records of the complainants themselves, that the gap between what the department had done and what the evidence warranted was, in her words, not a judgment call. It was a policy failure with a paper trail. The formal findings of Lieutenant Marsh's investigation, completed in 26 days, were as follows. Officer Derek Greer had conducted 7 stops of black-credentialed professionals in the research district over 4 years. All 7 stops lacked documented probable cause. In all 7, institutional credentials were presented and dismissed without verification. In 5 of the 7, language characterized by complainants as racially contemptuous was used. In 3 of the 7, unphysical contact was initiated without lawful detention basis. The 6 prior complaints had been dismissed using procedurally correct but substantively inadequate review processes that, when applied uniformly to a single officer's accumulating record, functioned as a systematic shield against accountability. Sergeant Whitfield's 3 performance evaluations describing Greer as proactive were flagged as supervisory conduct requiring separate review. The precinct's commanding officer was placed on administrative review pending investigation of supervisory failure. The union contract provision enabling isolated complaint processing was identified as a structural accountability gap and referred to the city's Labor Relations Office for contract renegotiation. McGreer's termination proceeding was initiated on day 14 of the investigation. Under the existing union contract, termination required a formal hearing before a review panel. The hearing was scheduled for day 22. The union provided representation. The representative reviewed the evidentiary package, 3 camera angles, 14 pages of my contemporaneous account, 2 civilian witness statements, Dr. Reyes's formal institutional report, the NIH incident log, and Lieutenant Marsh's 26-page investigative findings, and requested a 48-hour continuance. The continuance was granted. At the rescheduled hearing, the union representative made an opening statement that lasted 6 minutes. Then he conferred privately with Greer for 11 minutes. Then he returned to the panel and withdrew the contest. Greer did not speak at his own termination hearing. His employment was terminated on day 31. The termination letter was 4 paragraphs. It cited racial profiling, unlawful detention, physical assault without probable cause, dismissal of federal credentials without verification, conduct unbecoming an officer, and contribution to a pattern of discriminatory enforcement that the department had failed to identify and address through adequate supervisory oversight. That last clause was significant. It was the first time the department had formally acknowledged, in a written personnel action, that the failure was not solely Greer's. The decertification filing was submitted to the State Licensing Board on day 33. On decertification, the formal revocation of an officer's law enforcement certification, is the mechanism that prevents a terminated officer from simply moving to another jurisdiction and resuming patrol. It is the difference between an officer losing one job and an officer losing the career. The State Licensing Board completed its review in 40 days. Greer's certification was revoked on day 73 from the date of the incident. His name was entered into the National Decertification Index, the federal database maintained by the International Association of Directors of Law Enforcement Standards and Training that tracks decertified officers across all 50 states. He cannot work in law enforcement in any jurisdiction in the United States. He cannot apply. He cannot be hired. He cannot be reinstated. The database entry is permanent. The civil lawsuit was filed on day 30, 6 counts, unlawful detention without probable cause, racial profiling and discrimination under federal and state civil rights statutes, assault and battery, violation of civil rights under color of law, intentional infliction of emotional distress, institutional failure to train and supervise an officer with a documented pattern of discriminatory conduct. The evidentiary package submitted with the filing was 340 pages. It included every camera angle, every witness statement, every complaint file, Lieutenant Marsh's investigative findings, the NIH Federal Interference Log, and the university's Institutional Impact Assessment, which documented the disruption to active federal research activity caused by the stop, and a supplementary filing from the attorney representing the 3 prior complainants who had joined the action. The city's legal team requested a settlement conference on day 41. My attorney asked me what I wanted before she walked into that room. I told her 3 things. I wanted a figure that reflected not just the incident but the pattern, the 4 years of dismissed complaints that had made the incident possible. I wanted a public acknowledgement from the city that the complaint processing failure was institutional, not individual. And I wanted the reforms. Specific, documented, enforceable reforms, not a press conference and a pilot program. She walked into that room with all 3. The settlement conference lasted 40 minutes. The city's lead attorney spoke for the first 6. She outlined the city's position, which was, in its entirety, a request to discuss the figure and the public statement language. They did not contest liability. They did not contest the pattern finding. They did not contest a single clause of the reform requirements. My attorney told me later that in 22 years of civil rights litigation, she had never seen a municipal defendant arrive at a settlement conference with that level of non-contestation. She attributed it to one thing. They watched the footage, she said, all 3 angles, and they understood that there was no version of a trial that ended well for them. The figure they agreed to, the public statement they issued, as and the 34 institutions that rewrote their security protocols as a direct result of what happened in Bay 14 on a Tuesday morning in October. That is the final chapter. But I want you to understand something before we get there. The $6 million, the termination, the decertification, the federal record, none of it restored the morning I lost. None of it gave back the 4 minutes of the 6 people who came before me. None of it is the point. The point is what changes next, and whether it changes because of documentation, because of accountability, or because the next person stopped in a research district parking lot has a platform to make sure their story reaches you. That part, the part about what actually changes, is what I need you to hear last. The settlement was announced on a Thursday morning, $6 million, and the fastest resolution of a civil rights complaint against the city's police department in the institution's litigation history. 40 days from filing to signed agreement. The city's communications office issued a public statement at 10 a.m. It ran to 4 paragraphs. The first acknowledged the incident, the second acknowledged the pattern, the third acknowledged the institutional failure, the specific formal written acknowledgement I had asked my attorney to secure before she walked into that settlement conference. I want to read you that third paragraph. Not for satisfaction, not as a trophy, as documentation, because the distance between what institutions say privately and what they are willing to put their name on publicly is the difference between a conversation and a record. The paragraph read, "The city acknowledges that the complaint processing failures identified in the internal affairs investigation of this matter reflect a systemic deficiency in the department's supervisory review protocols, one that allowed a pattern of discriminatory conduct to persist across multiple incidents without adequate institutional response. This acknowledgement is not limited to the conduct of the officer involved. It extends to the supervisory and administrative structures that failed to identify and address that conduct." A city, in a public statement, acknowledging that the system failed. That paragraph took my attorney 40 minutes to negotiate. It was worth every one of them. The fourth paragraph of the statement outlined the reforms, not aspirational language, not a pilot program or a task force or a working group convened to study the question of whether something should be done. Specific, enforceable, documented structural changes, each one tied to a specific failure identified in Lieutenant Marsh's investigative findings. The reforms were 7 in number. Mandatory pattern review triggered after any second complaint involving the same officer, not the 14th. The second. Automatic external camera footage preservation for any stop occurring within 200 meters of a federally co-funded research or academic institution, removing the 72-hour rolling deletion window that had eliminated the footage from the 4th prior complainant's incident. Credential verification protocol requiring officers to attempt contact with the issuing institution before dismissing a presented credential as unverified. A 30-second phone call. The thing that would have ended my encounter in its first 90 seconds. Mandatory supervisor notification within 15 minutes of any stop involving a presented institutional credential, removing the discretion that had allowed Greer to operate without oversight across 7 incidents. Body camera footage review for all stops generating a complaint, conducted by a reviewer with no supervisory relationship to the involved officer, closing the structural loop that had allowed Whitfield's evaluations to characterize Greer as proactive while the complaint files accumulated. Union contract renegotiation to remove the isolated processing provision that had made the pattern invisible across 6 separate reviews, and a formal research district liaison protocol, a direct communication channel between the city's police department and the security directors of every federally co-funded research institution in the district, requiring joint review of any stop occurring on or adjacent to institutional property. 7 reforms, each one a direct structural response to a specific documented failure. Each one enforceable under the terms of the settlement agreement, with quarterly compliance reporting requirements and an independent oversight appointment to verify implementation. The reforms did not stay within the city's limits. 34 research institutions across 11 states adopted versions of the credential verification protocol within 8 months of the settlement announcement. The Association of American Universities issued a formal guidance document recommending the institutional liaison protocol for all member institutions with adjacent public patrol zones. 3 state legislatures introduced bills requiring mandatory pattern review after a second complaint for any officer in a jurisdiction containing federally funded research facilities. 2 of those bills passed. The NIH updated its grantee protection guidance to include explicit language about institutional response obligations when a credentialed grantee is subject to a law enforcement stop on or adjacent to grant-funded premises. The footage from Bay 14, all 3 angles, synchronized and time-stamped, was incorporated into law enforcement training curricula at 7 police academies as a case study in credential dismissal and its evidentiary consequences. It was also played in its entirety in a hearing room in Washington. I testified before the Senate Subcommittee on Science, Technology, and the Future of Research 5 months after the settlement. I wore the same lab coat. I carried the same laptop bag. I placed the same credential wallet on the table in front of me before I began speaking, not as theater, but as documentation. As a reminder that the object a uniformed officer had dismissed as purchasable online was the same object that had, in the intervening 5 months, been entered into a federal evidentiary record, cited in a city's public acknowledgement of institutional failure. Oh, and was now sitting on a table in a United States Senate hearing room. I spoke for 22 minutes. I said what I had said in the parking lot, in the security director's office, in the settlement negotiation, and in every conversation I had been part of in the months between the incident and that hearing room. This is not about one officer. It is about the system that produced him, protected him, and handed him 4 years of uncontested authority to decide who belonged in a research corridor and who didn't, based on nothing documentable, nothing defensible, nothing that would survive 30 seconds of evidentiary scrutiny. It is about what happens to the 6 people who come before the one who has the camera, the credentials, and the institutional infrastructure to make the pattern visible. It is about what accountability requires, not as a value, but as an architecture, specific, structural, enforceable, with compliance reporting and independent oversight and union contract language that doesn't functionally reward the dismissal of legitimate complaints. And it is about the work. The drug that patent US 9,847,203 covers has not stopped being distributed while I have been telling you this story. The 3.2 million figure I stated in Bay 14, on camera with a federal credential in my hand. That figure is not current anymore. As of the most recent quarterly distribution report, the number is 3.8 million. The 3.8 million people in 47 countries receiving an active treatment protocol for a disease that had no treatment before 11 years of federally funded work in a building that an officer glanced at and looked away from. 3.8 million people who did not know on the morning of that Tuesday in October that the researcher responsible for the compound keeping them alive was sitting in a legally parked car in a permitted researcher bay, being told he could buy his credentials online. They don't need to know. The work was never about recognition. It was about the problem. The unsolved, urgent, fatal problem that a decade of molecular synthesis work was trying to address. Officer Greer tried to stop me from entering a building. The building kept running. The work kept running. The number kept climbing. And it will keep climbing long after the settlement figure has been written into a city budget line and the termination letter has been filed in a closed personnel record and the name Derek Greer has faded from every professional database except the one that ensures he never holds a badge again. I want to ask you something before this ends. Not a rhetorical question. A real one, the kind I want you to think about and answer in the comments, because your answer matters and because the conversation that follows from it is part of why this channel exists. Should research institutions and universities and hospitals and any federally co-funded facility have formal jurisdictional authority over law enforcement conduct on their grounds? Should a credential presented by a grantee or staff member at a federally funded institution carry a legally mandated verification requirement before a stop can proceed? Think about what that would have meant for the research associate, the department chair, the NIH program officer, the biotech founder. Think about what it would mean for the next person who parks in Bay 14 wearing a lab coat that an officer's eyes move across and dismiss in under 2 seconds. Drop your answer below. I read them. The ones that change how I think about this get shared. And if you have watched this far, if you have stayed with this story from Bay 14 to the Senate hearing room, to the 3.8 million people who don't know any of this happened, then you understand what this channel is for. It is not for content. It is for documentation. It is for the account that gets told completely, with the evidence intact and the pattern named, and the structural failures identified by their correct institutional labels. Not softened, not sensationalized, not reduced to a thumbnail and a reaction. Stories like mine need witnesses who will carry them further than the person telling them can reach alone. If that is the kind of witness you want to be, subscribe. Not for the algorithm, for the record. He tried to stop a man from entering a building. That man's work never stopped. It never will.